Well, welcome everybody. Um, we apologize for the little technical issue there, and thank you all for your patience. Gotta love technology, right? But welcome. My name is Stephen Curley. I'm a member of the Federation of State Boards of Physical Therapy Board of Directors. We at FSBPT and the board want to welcome everybody to another regulatory hour. FSBPT is focused on providing educational content on key issues impacting regulation. Regulatory hours are presented every other month. The next regulatory hour will be coming up on December 17th and is called A Year in Review, Interesting Cases. FSBPT also has a webinar coming up on November 18th called Expanding PT Practice into Health and Wellness Services. Of course, next week is the FSBPT annual meeting. Most of the meeting is available via virtual if you're not able to attend in person. If you're interested, please go to FSBPT's website or contact communications at fsbpt.org. That being said, I hope I'm able to see all of you in Spokane. Today's regulatory hour is presented by Dale Atkinson and is regarding final orders, essential elements. This session will address final orders, including consent and settlement agreements, as well as post-administrative hearings. Without further ado, I'll turn it over to Dale.
Yeah, thank you, Stephen. And Rich, I can see you. You can hear me and you can see the slides. Excellent. And also apologies for the late start. I will finish by the top of the hour for those of you who are scheduled. So we will attempt to maintain that schedule as best we can. I also want to start by jumping right into our content here. No time for stories today or funny jokes or anything. So first off, welcome and thank you. I do this for all my presentations for all my clients, and that's a big thank you to everyone involved, board of directors, staff, and especially all of those that are on the line today for the important role you play in public protection through the enforcement of the Practice Acts. You're not thanked enough, so I will start by saying thank you and recognizing you as you duly deserve, no matter what role it is you play, board member, staff, administrator, executive director, assistant attorney general, or what have you. So big shout out, thanks. As mentioned, I'm Dale Atkinson. I'm an attorney and a consultant to FSBPT, and I enjoy doing these sessions. I represent a whole bunch of FSBPT-like organizations and have my entire career, so I'm hoping that my perspective and experience over time will assist in today's comments. So feel free to, by the way, join in, unmute, speak, shout out a question, type something in the chat, whatever it takes to make sure that we meet your needs insofar as today's topic is concerned. But again, feel free and don't hesitate to ask questions as needed. Rich and the staff, I think, keep an eye on both the chat and if anybody has a hand to raise or even unmute. So I don't mind you interrupting. So feel free to participate in that manner. And we might even ask you to participate. So let's start out with a volunteer that just wants to describe for us in a nutshell the process from complaint to resolution. So a matter is received by your board or the process or your department. Anybody willing to unmute and just give us a thumbnail of the process? And if so, Rich is going to give you dinner for two at your favorite restaurant, wherever that might be. Anybody willing? I know we're all probably still joining and in the late start, etc. But and if not, I will give my version, I guess, of a process that's followed. I want to acknowledge, number one, is that each jurisdiction might do it a little differently. And we know we have departmentalized jurisdictions, we have standalones, and we may have some composites as well. And so I try to speak in generalities. You all can digest it and place it into the context of your jurisdictions. But a complaint is received. It's got to be processed in some way, shape, or form. It may be signed, it may be anonymous, and a determination has to be made. Is it within the scope of the authority of the board? So it merits an additional look. It might merit investigation, and it might merit being pushed aside or disposed of or dismissed out because it's outside the scope of the board, etc. And the reason I think this is important to lay some foundation, by the way, and is final orders, which is today's topic, is a technical topic, It's got legalese to it. I think there's a few lawyers on the line. Feel free to jump in as necessary, but it's a little bit technical, but it's an extremely important aspect of your role as regulators and public protectors, because when that complaint comes in, it's determined to be investigated, and ultimately it's going to be resolved through whatever process it is that you follow. And that resolution is what I would put into the category of these final orders. And it is, again, it is vital that these final orders address some of the elements that should be addressed, so that anticipated questions in the future are resolved as best that it possibly can. So we've got complaint to resolution. Resolution could come at any point in time after the complaint is filed through some kind of settlement, consent, or what have you. It may go to a contested hearing, and then ultimately be decided as well. And so slides will come up on that. The idea here was to get to one of you to talk, but maybe perhaps you'll have something to say in a future slide here that's coming up. But so think about that process and think about the role that these final orders play. And again, if anybody wants to unmute and speak or type into the chat, what is a final order, and how is that determined, and how is it, of course, relevant to your role as public protectors and enforcers of the Practice Acts in the interest of public protection and consistent with the intent of the legislature, which, by the way, I try to say every presentation, because we all need to get used to describing this, articulating this out to whomever it is we may be speaking. So a final order, in my mind at least, and this is no definitions, there's no Black's Law Dictionary or anything else that's undertaken here. This is a Dale version of what is a final order, and to me it's a memorialization of findings that formally resolves a matter. And those findings, by the way, can come in many shapes and sizes, but we have to set the stage for, well, what are we really talking about today, and the topic that's before us. And of course, as I've mentioned earlier, how vital it is that these orders be understood and that they be articulated in a manner that is, one, fair to all the parties, but two, identifies the future issues that might surface. The intent here is not to turn you into lawyers or anything else, but I really think it's vital that attendees today, again, no matter what role you play, understand the nature of final orders. So we have a resolution of a matter, and what does that mean? And how are we going to then fulfill the obligations within the resolution of that matter, no matter what they might be? And I like to start, at least from a bigger picture standpoint, is well, how was the matter resolved? Is it resolved through an agreement? And I'm sure everyone agrees with the lower left picture here that when you all have a consent or settlement agreement, everybody is just happy as can be and they're smiling like this. That's probably not true. That's supposed to be a joke. But if through some kind of an agreement, a resolution in a consent order or settlement agreement, which the vast majority of your complaints are resolved through that. You probably already know that, but occasionally you will go in the upper right side of the same screen as the contested hearing. And how do those play out? And what does a final order look like post-contested hearing, as opposed to, if you will, a settlement or consent agreement, the lower left side? And in my mind, most of the elements of the final order are going to be the same, whether it's a contested hearing or a consent agreement, with some nuanced issues that'll be the last couple of slides. So excuse me. So regardless how you get there, you're going to get there eventually, and there being a resolution, that final order that exists. And so at least understand that the approach to them may be a little bit different depending upon the process that's followed. So as I've mentioned, most of your complaints are settled through some kind of an agreement. There's a consent arranged, negotiation between the respondent, who is the recipient of the complaint, and the board itself. And I'm reminding myself, do not forget about the complainant in this entire process. I do not have a slide on that, but complaints come in. Complainants have a right to know process, timeframes, resolutions, and others. So do not leave out of your equation of how you address complaints. Do not leave the complainant out of that equation. That's a very important aspect to this entire process. But so we have an agreement that's resolved through consent order, settlement agreement, you may have your own terminology in your jurisdictions, but you can look at this agreement merely or simply or as complex as you want, but it's a contract between parties. It's an arrangement, a contract, an offer acceptance, consideration, resolution that's reduced to writing, and then it's going to be, if you will, enforced in that manner. And because it is a contract, and hopefully the respondent has counsel involved, which I think eases the process, but um, it is a contract, and almost then anything goes. And because it's a meeting of the minds, it's an agreement, it's reduced to writing. And if there's representation on both sides, sometimes that, as I mentioned, eases the process. But you can come to your decisions through this negotiated process, and you may not be quite as restricted in what your statutes say insofar as sanctions that could be imposed. So you have a bit more flexibility and freedom, and I would suggest that you consider that in your process to the extent you're involved in your process of that kind of a resolution. So the agreement is just that. It's a contract between the parties, and it's resolved and reduced into writing, and then ultimately, if you will, enforced. If you have a contested hearing, which doesn't happen all that often in the world of administrative proceedings, but you will have those occasionally. And it's because the matter couldn't be resolved through a negotiated agreement. It's going to be resolved through a more formal process. And while administrative proceedings are not as formal as judicial proceedings, civil and criminal, they are a formal proceeding. There's rules that have to be followed. There's admissibility of evidence. There are witnesses, experts and otherwise. There may be motions or objections and et cetera. But in the end, the outcome is imposed upon the respondent rather than agreed upon through that negotiated settlement agreement. So the imposition of findings and ultimate conclusions that results in a sanction is a bit of a different approach than that contractual settlement agreement that we spoke of on the previous slide. And that imposition upon the respondent changes the perspective, and it certainly changes the reaction of the respondent that is subject to the sanctions and the disciplinary actions. So we start with, and there's some nuances at a later slide, but in general, in my mind, the elements of all final orders are going to include findings of fact, conclusions of law, the burden of proof, and we're going to have a slide for each one of these, the burden of proof, sanctions with specificity, reinstatement rights, if any, publicity, that it will be publicized, and perhaps the right to appeal, consent orders or settlement agreement. You may not have a right to appeal, but while I'm on that topic now, of late, especially with the First Amendment free speech versus conduct litigation that's been going on of late in multiple professions, you'd be surprised how many matters are resolved through a consent agreement or settlement agreement, consent order or settlement agreement, and then right on the tail end of that, litigation is filed contesting some matter of it. So whether you call that a right to appeal or not, is going to be up to you. But there are more cases than you might think that result in post-agreement litigation over some legal issues that could surface. So the importance of these final orders now, if you take anything from today's comments, is you're clarifying today and preparing for tomorrow. If there's a 5-year suspension and there's a reinstatement petition after 5 years, you may no longer be on the board, or you may no longer be the executive director, and the historical or institutional knowledge may not always be there. These final orders should answer or attempt to answer all the anticipated questions that might surface that result in the eligibility and or decision to reinstate a license that was subject to an adverse action. And again, whether that is a consent order or post-contested hearing doesn't matter, so to speak. But look at it as you are clarifying today, because you're going to prepare for tomorrow. because in the vast majority of cases, adverse actions are subject to reinstatement petitions, and there are rarely permanent revocations that exist, but some do. So you can take that to heart, and you can certainly seek some counsel on that. So the first element, findings of fact, an accurate and complete record of what occurred and what was established via the record itself. The proposed findings may go back and forth between the parties or counsel for the parties. They're disseminated and sometimes negotiated for comment prior to their finalization. But the point being is the findings of fact are going to lay out and substantiate what occurred that ultimately then resulted in a breach or violation of the law that then subjected the respondent to some kind of adverse action and or sanctions. So the findings of fact will explain that, and as you read an order, it should tell the story. So you should know that, and it should, as the outside reader, I should be able to identify that. The conclusions of law are what was breached, and how do the facts that have been established of record substantiate a violation of the law. And law, by the way, remember, is both statute and regs. So when we use the word law generically, we're referring to both statutes and regs. If it's specific to a statute, we would say statute. If it's specific to a regulation, we might say regulation or rule. But either way, the citations will be undertaken in these final orders to identify the basis for the sanctions that are about to be imposed. So those conclusions of law will be cited within there, within the final order, and they will mirror, most likely, and they should, the complaints that were filed and the allegations of wrongdoing. So those should match up. And if there's a complaint and it ripens into a formal charge and there's citations to statutes that are alleged to have been breached, and through the investigation, additional issues are uncovered and new allegations are had. If it results in new allegations of a violation of different statutes, those should be amended to mirror the allegations that occur. And so you will be relying in part upon the complaints and the formal charges when you reach your conclusions of law issues as part of that final order. And your lawyers are going to do most of this, but I want to emphasize that having this knowledge as a board member and or staff of a board can be very important. It can be very helpful in understanding the process and the regulatory and administrative process. So that's why we're covering this today, and in part that's why it's a little bit technical, but it's there, and hopefully this is helpful to you. The burden of proof or standard that is met in order to substantiate that wrongdoing will be in that final order. It might be in the first sentence: by a preponderance of the evidence, the board hereby finds the following, and you carry on from there. But it should be referenced in there for two reasons. One is you're telling the world we know what the burden is. And two is you're substantiating how that burden then has been met for purposes of the finding of wrongdoing. In most jurisdictions, it's a preponderance of the evidence. Preponderance is more likely than not the 51-yard line of a football field. But preponderance, and again, it would be referenced in this final order. Clear and convincing in some jurisdictions, not that many, but does exist. And what is clear and convincing versus preponderance? Probably hard to define, but it's something more than a preponderance, something less than a criminal standard of beyond a reasonable doubt. And I put that up there in the slide as well to remind us that the standard does vary between administrative proceedings and perhaps civil proceedings, but administrative proceedings and criminal. So you can have a situation where an individual is exonerated criminally because of the higher standard, but still, if you will, convicted or found guilty of wrongdoing administratively. That can happen because of these differing burdens, and the burdens differ again because the rights that are at stake in a criminal proceeding, fundamental rights are at stake. In administrative proceedings, the licensee may call them fundamental, but they're different, if you will, from the criminal proceeding. So understand the burden of proof, what it is in your jurisdiction, and it will be incorporated into that final order in some way, shape, or form. So you'll eventually get to the sanction options now. And there is significant flexibility when you have a consent order or a settlement agreement in the sanctions that are imposed. And I believe that the meeting of the minds of the parties, as we talked about earlier, related to a consent order or settlement agreement, provide this kind of flexibility for a board to determine what is in the best interest of the intent of the statute and the public to be protected. And you can be pretty creative, I think, about what sanctions will be imposed as part of that. And as a reminder, it's because the parties have come to an agreement, and you do agree that these are going to be the sanctions under these particular circumstances. So we'll start with at least that kind of flexibility and the creativeness that might exist in the negotiation process. Just again, depending upon the fact pattern that's occurring, will help dictate how you want those sanction options to be identified. But we can be more specific now in general, but you need to know what your statutes and regs say that provide you with the authority, not only the authority to impose sanction, but what those sanctions might be. And so I'm used to seeing in the Model Acts that I assist my clients in drafting that the board may refuse to issue, refuse to renew, and those, by the way, are important. So pause on that for a minute, but may refuse to issue, may refuse to renew, or impose the following sanctions based upon the following grounds. And then you're going to have pages of grounds for discipline, misrepresentation, fraud, criminal convictions, what have you. But that refuse to issue, refuse to renew, or impose other sanctions is where you're going to at least find the basis for the authority of the board to act. So that's why those first two are listed up there, because those can be important tools related to the issuance of a license on an application if you have an individual who is engaged in conduct like unlicensed practice that might result in the denial of a license. But returning to our topic today of final orders, you're going to determine, well, what are we going to do from a sanctioning perspective? Reprimand, censure, limit the practice, suspend, revoke, cost, fines, evaluation, substance abuse, supervised practice, competence assessments. You have to take the exam again, or I should say you have to pass the exam again, or more. So you probably have more flexibility than you think, but you're going to see some kind of a list within your statute. And then historically, you will find previous adverse actions that have been rendered by your board that is going to give you some guidance as to that. So if we stopped on a few of these and looked at them, and so, censures and reprimands, is that a minor violation, or are there minor activities that are not in need of a much more substantive sanction that you can think of? Limit or restricting practice, based on allegations of wrongdoing, and you can practice with only certain genders or under supervision. When I should have put supervision up here. Oh, it is supervised practice. So, the point is that you are going to fashion the sanctions and the remedies based upon the fact pattern with the ultimate consumer and public protection in mind. And you're going to figure that out. And you will have historical institutional issues that have been occurred over time. So suspension and revoke. The next slide, I'll talk about revocation a bit. So let's start with suspension. And you cannot practice for a certain period of time. But what you're going to do is you're going to delineate that, as you see on the left, with specificity. So suspension from practice for 6 months, automatic reinstatement based upon the passage of time. If that's how you want it, that's how it's going to state. Suspension for 2 years, subject to reinstatement based upon the respondent complying with the following, and you list a lot of things: drug and alcohol abuse tests, or random drug testing, or psychological evaluation, or retesting because it's a competence issue. Take the laws exam again. Whatever the pattern might be, that has to be in these final orders. And by the way, the well-written final orders are not only important to you as the regulator and the future regulators, it's also fair to the respondent. I know how I can get my license back, if ever, and what I must do in order to comply and ultimately seek that reinstatement. So these well-written orders are beneficial to everyone involved. Administrative systems like a licensure system with physical therapists and assistants is beneficial to everyone involved because of the constitutional and other due process rights wrapped around it. So this is consistent with the entire licensing schemes that do exist there. So we'll skip revoke for now. It's the next slide, but costs and fines are going to be placed right into these final orders. So you may be assessing costs if you have the authority to do that. You may be imposing fines. The difference between costs and fines, of course, are costs reimbursed the board for out-of-pocket expenses related to the administrative prosecution of the matter. Fines are intended to punish and deter future conduct. Both of those have to be in statute. They should be delineated separately in your final orders if you're imposing both upon them. And those fines and or costs must be paid as part of a process to seek that reinstatement if they're allowed to do that. So I'm sure that you on the line today could think of other options for sanction that do exist that you probably have the authority to do and undertake, but here's at least a little bit of a laundry list of those. I stop on revocation because I talk about this a fair amount, and as part of a sanction option and a final order, if you're revoking a license, is it permanent or not? And I review a lot of cases, and rarely do I see permanent revocations. But I talked about a couple of cases over the weekend that did involve permanent revocation. But if you're going to impose that, one, do you have the authority? So seek your legal counsel on that. And two, if you determine to impose that, then it's going to be in the final order. Permanent revocation, no right to reinstatement, something along the lines of addressing that. If you don't have the authority to permanently revoke and or the circumstances don't dictate such a harsh sanction, well, then you might want to consider something other than revocation, because revocation will be argued that you've taken the license away and you no longer have administrative authority or jurisdiction over that person. And if they continue to practice, you may have divested yourself of the authority to take an adverse action against the individual. So think about revocation, what it means, what revocation means, and the authority you have and importantly, do not potentially have. And remember that the public believes revocation is forever, generally. So the consumers are going to believe that. So you're going to want to at least figure that out and how that might best work. And obviously, under the circumstances, you're going to determine what is appropriate. I'm a big believer in the group decision-making process of regulatory boards. And if you determine to permanently revoke, that's going to be the right decision. If you determine to suspend, that's the right decision as well. So you'll figure that out. But the important piece is, what authority do you have? And then how are you going to write it up in that final order? So that's today's topic. Now, reinstatement rights, if any, extremely important aspect of a final order. Am I able to reinstate? And how is that accomplished? And to whom do I petition for this reinstatement? Now, if you, on the right side of the slide, if you drop down to the bottom, there's a fair number of cases where a criminal court will impose an adverse action against a licensee, like a, if you will, surrender, don't like that word, but a surrender of licensure or a revocation of licensure as part of a criminal penalty of a defendant found to be guilty of the criminal statutes. So now you think about, well, how does a criminally sanctioned licensee seek to have reinstatement? Do they go back to the criminal court, or do they go to the board, or some combination thereof? I am an advocate for criminal courts, if you will, indefinitely suspending a license and referring the matter to the regulatory board to determine what's the appropriate sanction administratively, so that the administrative body, you all on the line today, are determining the fate of the licensure status taking into consideration a criminal conviction that exists, and you'll figure out what's right to do and you'll do it. But so you think about that. Now, with a loss of licensure, whether it's revocation or otherwise, in my mind and in my opinion, it is always a petition for reinstatement of that license. It is not an application for a new license. So if I'm suspended from practice for 3 years, I seek reinstatement of a suspended license. If you revoke my license and your statutes say I can't seek a license for 2 years, in 2 years, when I seek licensure, it is a reinstatement of my revoked license. It is not a new application for licensure. And boards want sometimes think about or perhaps want to treat it as a new application for licensure. We don't want something to get lost in the mix of multiple license numbers over time, et cetera. We also want to make sure that the notice and the ability of your fellow regulatory boards, your surrounding and other FSBPT member boards, understand the historical issues related to a licensee who may be moving and endorsing into a different, an additional jurisdiction. So understand the reinstatement, how it works, but again, do not forget that a sanctioned licensee should always be seeking reinstatement. If they seek a new license, I would turn it into a petition for reinstatement. And there'll be a way to do that. Your lawyers will help you, but this is a conceptual issue that I think is important for all of us to understand. Publicity, good to put, again, vital to put into a final order. It's final, and it's subject to being noticed up. So it's going to be on the website, it's going to be in our newsletter, perhaps on social media. It's going to be turned over to FSBPT as part of their exam licensure disciplinary data bank, or anywhere else, HIPDB, or anywhere else that you may be disclosing this. In fairness to everyone involved, including the respondent, it's worthy, I think, to tell as part of your final order that this is subject to a public record. It's subject to publicity, and the board will make that available via its social media and website presence. Again, this is just a fairness issue. It's also then important because the public has a right to know and search and see the status of a particular licensee related to their license and the status of it, and for purposes of making a determination, should I seek services from this licensee? And in preparing for not only today and looking at some final orders and trying to find them, I will say this, that many of the jurisdictions' websites that I visited, it was difficult, if not impossible, to find final adverse actions regarding licensees. So to the extent you have control over your websites, make sure that they're accessible to the public. I know what I'm looking for when I get to your websites, and I can't find some things, and it can be a little bit difficult. So this publicity is not only important in your final order, it's important, I think, as your obligations as a regulatory board. So don't lose sight of that, but put it in the final orders in fairness to everyone involved, including the respondent and the public that may be interested in that. There will be a notification affirmatively within the final order of a right to an appeal, citations to statutes and/or time limits, or both that exist. This right to appeal may not be in the consent order that you resolve through that agreement or contract we've talked about, but do not forget that this is one of the aspects that exist, and should be perhaps noticed up to the individual. Now, there's other provisions, and the slide that showed all the boxes and the findings of fact, conclusion of law, all of that. I didn't put all these other nuances that might exist, but use of counsel, waiver of rights to a hearing if I'm entering into a consent order, waiver of conflict of interest if a consent order has to be approved by the full board, and if the board rejects that, and I come back before with a formal hearing before that same board, I'm waiving any rights that that board is now tainted and conflicted. So there's a lot of legal, technical issues your lawyers will help with, but sometimes it's good to say those out loud that exist. And I see a question coming. Do you recommend the final order should be available to the public based on category? I've never been asked that, Jason, and I don't know if anybody else who sees this chat, you want to weigh in on if you do that. I would think that as long as it's by licensee, so if I'm thinking about going to Dale as a licensed physical therapist, I'm going to look up his status. I'm going to look for Dale. I'm not going to look for revocation or suspension or other aspects. But that's kind of an interesting question. So if anybody either wants to unmute or add to the chat, help Jason out. Is anybody categorizing their adverse actions by the sanctions in addition to by the person? Um, and so Jason's saying here as a follow-up, they're viewable if you know the name or license number. I don't know that. So so he's bringing up a good point. When I went to some of your websites, and again, in preparing for today, I just want to just see the action. So what I usually end up doing is finding your minutes, and or if you have a section of your website that deals with final adverse actions, I can click on that, I can see them, and then I can navigate through. And I'm just, I'm learning. I'm not necessarily ensuring that my practitioner's license is in good standing. So FSBPDs are fine too. You've seen some states that group them by category of violation. Okay, so this is a great question, and I'm not the best searcher. I don't feel like on your websites, but let's make it as available as possible. And here's one of them. Here's one of the questions. Mark is saying recommended orders and administrative whoops, it's going on. Would be public. Yeah. So to me, they all should be public. We're going to get the slide just a second on that, actually. Additional nuanced issues in our, and again, I want to be respectful of everyone's time. So, as I mentioned, we'll be finished by the top of the hour, but I'm very happy to see everybody putting in your chats. So a couple of other additional nuanced issues. Lawyers are going to come in there and ask for is there no admission of wrongdoing? And depending upon the circumstances, your lawyers and your subcommittees that are negotiating these consent agreements, you're either going to agree to it or not. I am not a fan of no admissions of wrongdoing because the effects that has on the endorsement process and the mobility and portability of individuals. But again, this just depends upon the circumstances. So you can navigate that, negotiate that, and figure it out through your resolution process. Others will also, in addition, ask for this is a non-disciplinary action. We don't consider that to be discipline. I don't know what that actually means, and I think that it probably is inconsistent with the reason regulatory boards exist. If you find a reason to take an adverse action, it's a disciplinary action. In my mind, simplistically thinking, there could be some fact patterns that arise. And then lastly, or that third bullet is private orders. It's not public. And it's kind of what we're getting to here. And what a lot of your comments seem to be saying that you're posting. Final adverse actions, in my mind, are always public, period. End of discussion. And there's nothing beyond that. And by the way, even if an appeal is pending or filed and then pending, still file or still publicize or at least place on the website that this final adverse action has been taken. I have a right to find that as a consumer. In fact, my rule would be I'm going to put it on the website and it's going to be made available to the public unless a judge tells me otherwise. So if the respondent wants to run into court and have some stay entered and have it taken off the website, let them make that argument. I believe your rule should be publicize it. So some great comments coming up. So please feel free to use to look at those, and FSBPD, you can capture those as well. The last thing on this nuance slide is there's no such thing as a voluntary surrender. And I believe strongly of that. There's nothing voluntary about a complaint being filed, an investigation being undertaken, and then the licensee says, I'll give up my license. That's not voluntary. That is a contested matter. potentially, and or it's a settlement agreement that is negotiated between the parties. So that's not a voluntary surrender, maybe a surrender, but the point being is that that phrase voluntary surrender has changed over time. And in the course of my, 38 plus years of practicing law, this has evolved a bit, but I still occasionally hear this. Well, they voluntarily surrendered their license. No, they didn't. It resulted in a consent order or settlement agreement, and it has sanctions attached to it. So at least be aware of how this issue might arise, what it means if you happen to see it. But I don't believe it should be incorporated into a final order. There may be an agreement to surrender that license, but as I mentioned, it's not necessarily voluntary. The case law that you see that address final orders and appeals that might occur cover kind of a wide range of topics. If you deviate from, for those of you who have administrative law judges and hearing officers, for those of the boards that then ultimately make the decision and the ALJ or hearing officers recommendations come to that board, if the board doesn't agree with it, you better substantiate why you don't agree with it, especially if you are enhancing and or diminishing sanctions. You're going to want to put that in your orders. So it's important to substantiate that. So if there's an appeal and an argument that the board enhanced the sanction or disagreed with the recommendations, why did they do that? Why did the board not agree? So deviation from that, accepting or rejecting findings of fact, witness credibility. There's a lot of issues that can surface, technical legal issues that might affect how your final orders are actually drafted, and the deference principles of who ultimately makes these decisions, and or do you rely upon the ALJ or hearing officer and give deference to their findings because they heard all the evidence, they heard the credibility of the witnesses. So lots of nuances that might surface out of that affect how final orders are drafted. Follow your advice of counsel. And these are technical issues I talked about today. So seek that advice, learn about final orders, and follow that advice. But FSBPT and your access to the collective wisdom of your organization can provide some nice guidance related to that. But ultimately, you're going to follow the advice of counsel. So that is my last slide. I do have a thank you slide. I don't know if anybody has any questions or comments they want to make or unmute. These are some great chat issues. I didn't get to all of them, but everybody read those, take those to heart. This is collective wisdom of the organization, and that's a big part of why FSBPT exists, is to provide these opportunities for you all to talk to each other. But I will end my remarks, but if anybody has any questions, I'm happy to try to answer those or listen to comments. But I want to end my remarks how I started them. A big shout out, thanks, Board of Directors, Stephen, you and the group for what you do. Rich, you and the staff for operationalizing the programs that are extremely important, but everybody on the line today, no matter what role you play, you deserve some big thanks and recognition for the important public protection aspects of regulating physical therapy and physical therapy assistants. So I will turn it back over to you, and I wish everyone well in your annual meeting next week, I believe it is. So thank you for having me. And Stephen, I'll turn it back to you or Rich, or if anybody has any questions, please feel free to ask those.
Thank you, Dale. And, your advice about listening to your attorney, my youthful attorney as an investigator of 23, the attorney that I listen to the most is actually on this call. So that's a nice little, but if you have a question, feel free to put it on the chat or raise your hand, and we can get you hopefully answered for Dale. I'll give you guys, if anybody has any questions, a few more minutes here, but if you don't have any questions, appreciate your time. Again, apologize for the technical issues, but thank you all for joining us, and I will hopefully see you guys next week. If not, then in November for the next webinar.